morning, and thank you for joining us. We're going to spend some time today talking about how to obtain a green card based on the employment categories. In particular, we're going to focus on obtaining a green card through the PERM process. A few things before we get started. Scott Legal is a full-service immigration firm and focuses on a number of different types of visas, including green cards through employer sponsorship. We do webinars frequently throughout the month on a variety of different immigration topics. And at the end of this webinar, we'll send out a few things. One is a PowerPoint that you'll see here today. Another is a comprehensive guide to the PERM process, and also a link to where you can sign up for additional webinars. I will be the panelist today. My name is Kelly Weiner. I am a partner at Scott Legal and have been processing employment-based green cards for many years. If you have questions, please go ahead and send them through the chat box. And finally, this webinar is being recorded and will be made available on demand and on our YouTube channel. So we will get started. All right, so how do you obtain an employment-based green card in the US? So there are these categories called the EB categories for employment-based. And they cover, several different topics, several different options, some of which we'll go into in more depth and some of which we won't really cover today. So we'll just briefly go through them. So we have the EB1A. This is for people of extraordinary ability, people who've risen to the very, very top of their field and can show sustained national or international acclaim. We do have a separate webinar that we present on this type of green card. There's also the EB1B. This is for people who are working in outstanding researcher or professor categories or for those types of employers. The EB1C, this is multinational managers or executives. So maybe people who, often people who come on the L visa temporarily as managers or executives, they may use this route to get their green card. We have the EB2 category, and within this category, there's two subcategories. So in the EB2 category, in order to qualify as a threshold matter, you have to have either a U.S. advanced degree, meaning a master's degree or higher, or the equivalent, or exceptional ability. So exceptional ability is a little bit of a lower standard than extraordinary ability, and that can be used as well to qualify for the EB2 as a threshold matter. Once you meet that threshold requirement, then there's two ways to proceed. One is through something called the National Interest Waiver, and one is through the PERM, also called company sponsorship. So the PERM or company sponsorship, that's kind of what we call the normal process. The National Interest Waiver is a request to waive the normal labor certification PERM process because the person is working on an endeavor that has substantial merit and national importance to the U.S. on balance, and the person themselves is well positioned to advance the endeavor. And then on balance, it's beneficial for them to, waive the labor certification requirement. So if you are interested in the National Interest Waiver, this is another category where we have, specific presentations that are specifically on the National Interest Waiver, but it can be a good option. For example, if you're an entrepreneur, if you're working in an area of extreme importance, to the United States and kind of, medicine or, research or, technology, these can be really, strong petitions, but definitely are complex. And so, if you have more interest in that, I'd encourage you to check out the webinars we have that are specifically on that topic. There's the EB3. So this is for professionals, skilled and unskilled workers who can qualify through the PERM process, also called company sponsorship, which we'll talk more about in the coming slides. There's the EB4. This is a special immigrant category that covers many different, categories, including like religious workers, not something that we're going to cover today. And then EB5. So this is even though it's in the EB category of employment-based, it is really has an investment component as well and a job creation component where the applicant has to invest either $800,000 or $1,050,000 and, create 10 full-time jobs, within a period of time. This is something that, again, we have other webinars that specifically focus on the EB5. So if you're interested in that, I would encourage you to check those out. All right, let's talk a little bit more about the labor certification process, also called the PERM process. So this is the process by which a company will sponsor an employee or a foreign worker who's not yet working for them for a green card in the United States by offering a permanent full-time job. So this is a very common category, people who maybe, go to the university in the United States, maybe they get an H-1B, and then their employer says, hey, we'd like you to work for us permanently. We will sponsor you for the green card. That's one way it can happen. It's not the only way. And you also, don't even need to be actually working for the company for them to sponsor you for the PERM. It is for a future position. So I think that's something that people get confused about sometimes. So the categories for this are the EB2 and the EB3 category. As I mentioned, people who, either have the advanced degree or exceptional ability, and the job also requires the advanced degree or exceptional ability, can qualify for EB2. EB3, if the job requires at least a bachelor's degree, then that's what's called professionals. And then there's also skilled workers, where the job requires either 2 years, or more of education, training, or experience, and then unskilled workers where the job requires less than that. And there's a more limited number of, green cards available for people in the unskilled workers category. All right, so the PERM is a three-step process. The first step is the PERM, the actual PERM, where lots of things are filed with the Department of Labor. The second step is Form I-140. This is an immigrant petition filed by your employer with the government that says, yes, we want to sponsor this person for this job. And then finally, Form I-485, that's the actual green card application. You can also apply for the green card through something called Consular Processing, and we'll talk a little bit more about those two options later in the presentation. So for the PERM, what I'd say is the biggest and longest part of the three-step process. The first thing the company has to do is draft a PERM compliant job description. So, most job descriptions will include, kind of required and then preferred qualifications, right? So, great team player, maybe a bachelor's is required, but a master's is preferred. So for a PERM, you're not allowed to include that preferred information. The government requires that the employer draft the job description to only include the minimum requirements to do the job in a reasonable manner. Like if you had to hire somebody off the street tomorrow, what is the absolute minimum level of experience and education they would need in order to do this job? And the reason is that throughout this whole process, the government's position is that if the company wants to hire somebody who's not a U.S. worker, first they have to prove there are no U.S. workers in the area who can do the job. And so to make it as open as possible to the U.S. workers, they, require that the employer only include those minimum requirements to do the job in a reasonable manner. Once the job description is drafted, then they can submit what's called a prevailing wage determination. So this is when you send the job description and details and location and all of that to the Department of Labor. They will review it and then they'll assign an occupation code as well as a prevailing wage. And that prevailing wage that they assign is the minimum wage that can be paid once the green card is granted in the future. Additionally, the employer needs to be able to demonstrate through their financials that they can actually pay that wage. So it is, if you get a certain occupation code and the required minimum salary is way higher than the employer is willing to pay, that can definitely be problematic. Once the prevailing wage is issued, then you move on to the recruitment process. So in the recruitment process, that's where the employer is actually going to test the U.S. labor market. They're going to place advertisements. They have to review resumes. If anybody appears to be, qualified or it's ambiguous from the resume, they need to interview them. So and I do see someone sent in a question, and I will get to questions at the end of the presentation. So don't worry about that. I will get to that question. So during the recruitment process, they're interviewing applicants. This process is about 60 days long at a minimum because the advertisements need to be placed for at least 30 days. And then there is what we call kind of a 30-day quiet period. That's where there may not be advertisements running anymore, but the employer is still required to review resumes and interview people if they, seem qualified. If during this process, the employer does find a willing, qualified, and available U.S. worker who can do the job, then the PERM process does have to stop. The whole purpose of testing the labor market is to see if there is a U.S. worker who can meet the qualifications. And if they can, then you cannot proceed with the application. That being said, it doesn't mean the employer has to actually hire that worker. I think that's something that comes up sometimes. The employers are worried. No, they do not have to hire that worker, but it does mean they cannot proceed with the green card application. If you get through the recruitment process and the employer does not find any willing, qualified, and available applicants, they can go ahead and submit the labor certification, also called the PERM, to the Department of Labor. Those applications are taking about, 12 to 14 months to be adjudicated. So they can either be approved, denied, or audited. If they are audited, they will likely take longer than 13 months. And so audited means that, the government wants to see all the proof that the employer conducted, recruitment in compliance with the PERM requirements. So they might ask to see, copies of the resumes, copies of evaluation sheets where the employer explains why this person was not qualified for this job. If they review that and they feel that any of the compliance requirements were not met, then unfortunately the case can be denied. There can also be certain things about your case, what we call audit triggers. So this is what makes the case riskier, makes it more likely the Department of Labor will audit your case. So if there's a foreign language requirement, this is obviously a way to eliminate a lot of US workers. So there's very high standards for including a foreign language requirement. So if it's for a job that's not something obvious, like a Spanish teacher, and you have that language requirement, it is very risky for the case. Also, any requirements outside those normally required for the occupation. So the Department of Labor has their own view of what is normal for any particular for any particular job. If the job description says, well, we require 15 years of experience and a PhD, that's well outside the scope of what most jobs require. The government may require that the employer submit business necessity documentation, proving that this is a reasonable, something that is really needed to do this job. That can also be an audit trigger. As mentioned here, the Department of Labor filings, these are all filed with the Department of Labor for the PERM. You do not file with U.S. Citizenship and Immigration Services yet at this part of the PERM. In terms of timing, I know there's a question kind of related to this, so for the job description, that can sometimes take, very little time if the employer is very responsive, or maybe even a few weeks. Prevailing wages are taking 6 to 8 months to be issued. Then the recruitment, that takes about 2.5, 3 months. Then the case goes to the Department of Labor. The actual 9089 gets filed. Those are taking 12 to 14 months. So yes, I think it's this person is asked, I've heard the PERM process currently takes 2 years, 1 year to obtain the PWD, another year to get an approved 9089. Is that true? So the PWDs are not tending to take a year. They're taking closer to 6 to 8 months. That being said, if it's a really complicated type of position, yes, like it could take longer. And unfortunately, yes, the 9089s, they are taking about a year, sometimes even more than a year, a couple months over a year. So that is something we're seeing, that even this first part of the process is taking a very long time, because those processing times, you're already waiting, a year and a half, a year and 9 months just for the prevailing wage determination and the 9089. That's not including all the time to actually do the recruitment, which can take some time as well. Moving on to the I-140, if your PERM does get certified, then you are able to file Form I-140. So this is a form that's filed by the employer. And what this form will have is details of the job. It will also include all the proof that the applicant meets those requirements. So if the job requires a specific bachelor's degree plus 2 years of specific experience, then the I-140 filing is going to include proof of the education and also employer experience letters outlining that experience. Additionally, the I-140 has to include proof that the company itself can pay the prevailing wage or the offered wage. So whatever the offered wage was in the PERM, the employer needs to show that they can pay it. Generally, by regulation, they have to include, financial statements. This could be audited annual reports, could be tax returns, public financial statements. There's also supplementary documentation that can be provided. For example, if the employee is already being paid this wage, you can also submit perhaps their W-2s showing they're already making this money, so that the employer clearly can pay them. And if you have a very large company, over 100 employees, then sometimes you can have, a financial officer of the company who signs a letter explaining that the company can pay the wage. The I-140, the benefit in terms of timing is that you actually can pay to get a faster answer. So you can pay a premium processing fee, and the government will issue a response within 15 business days. Could be an approval, a denial, or a request for more evidence. If it's a request for more evidence, then you prepare the evidence and send it in, and then they'll issue usually that final decision within the 15 business days. The last step is the green card application step. And this can be done two ways. One is the Form I-485. That's what you're going to file to do an adjustment of status from within the United States. The other option is consular processing. That is where you get your green card outside the United States. You travel, either if you're living in a country abroad or the last country you lived in before the US, you travel to that country, and you apply at the US consulate. In terms of timing, we've said, is it current? Is it not? So what this means is there's only a certain number of employment-based green cards that can be issued in any given year. And because of the way the system works, there are backlogs kind of in the ability to qualify for the green card. So, when you submit your PERM application, you get something called a priority date. So that's the date that says, you're allowed to submit your green card, if the visa bulletin allows for it. So if you look at the visa bulletin, this is something that's issued each month, by the government, and it will tell you if you are allowed to file your green card application or not. So if your category is current, then yes, you can file, or if your priority date, if the dates on the visa bulletin show that, your priority date is currently being allowed to file applications, then you can go ahead and file. Unfortunately, for many people, they may find that the I-140 is approved, they have their priority date, and maybe now they're waiting, even sometimes for several years. Unfortunately, particularly applicants born in India or China are facing significantly long backlogs in the EB2 and EB3 category. And unless there is kind of immigration reform, which seems very unlikely at this time, those delays are likely to continue. We'll talk a little bit more about, what that means later in the presentation. Also for family members, so family members, your spouse, and any unmarried children under 21 are able to join the green card application at this phase of the process. All right, let's talk about the two options for getting your green card. So this is either adjustment of status and then also consular processing. So with an adjustment of status, that's where you have to be in the United States in a valid status that allows you to adjust status. So for example, for an employment-based case, people on ESTA, that's not going to be available. But for many people going through this process, they're already in the United States on a work visa because they have this relationship with an employer who's willing to sponsor them. So for those people, when they're living in the US, their family's here, maybe their kids are in school here, generally filing the I-485 is a better option. It does, once it's filed, it gives you the ability to remain in the US. So let's say you were on, for example, an L visa and the timing of the L ran out and you couldn't extend it. If you had already filed your I-485, you'd still be able to stay beyond that, based on the pending, I-485 adjustment of status. When you file for the I-485, you can also file for work and travel authorization. Those applications are taking some time to be approved. They're not very fast. It's usually a process of months. So you do have to kind of factor that into your planning when you're thinking about, your work, and if you don't want to break in work authorization, you really need to plan ahead to the extent that it's possible, with the priority dates. Also, most applicants, have had an interview with a USCIS officer. So, over the past few years, this has really changed. There's been less interviews, coming up in the next few years. I think we can anticipate more interviews. Essentially, what this means is at the end of the process, before USCIS will approve the green card case, they'll call you in, you'll do an interview with them. They'll ask you questions about, the underlying job and the petition. They'll ask you questions about your Form I-485 and your biographical and personal information. And then if the case is approved, they will let you know and your green card will be mailed to you. If you go through consular processing, so again, this is a process that happens completely outside the United States. This might be appropriate for people who either maybe their visa ran out and they didn't have any options to extend, and so they had to leave the US and wait for the green card abroad. Additionally, if somebody's not on an H-1B or an L and they really need to be able to travel constantly, they cannot wait the several months for, this travel authorization to come through, then they may also prefer to go to the consulate, because that will mean that they're not kind of, locked in the US once the I-485 is filed. With the consular processing, the way it works is the I-140 approval is sent to the National Visa Center. The National Visa Center, will issue a welcome letter saying, please provide this information. The applicant will complete an online form called a DS-260 that has a lot of biographical information, and then submit supporting documents to the National Visa Center, things like birth certificates, marriage certificates, police records. Once the National Visa Center reviews the documents, which takes a few weeks, then the file is sent to the U.S. consulate for scheduling. So that's where sometimes the timeline can extend because consulates are kind of all over the place in terms of how up to date they are on the immigrant visa scheduling. So some consulates are very fast, some consulates are very slow. So you do need to take that into account when you're thinking about where, which option to go with. The applicant then must attend an interview at the consulate. Every applicant who does consular processing will attend the interview. You have to get a medical exam done first, attend the interview. And again, similar to the USCIS interview, they'll ask questions about the job, they'll ask questions about, the immigration history. And then if the application is approved, you'll get an immigrant visa stamp in your passport that's usually valid for about 6 months. The person must enter the United States during that 6-month period. And then after they enter, then the green card will be mailed to them at their address in the United States. All right, who can pay for green card fees? This, I think, is a common question. The fees related to the PERM process, the actual sponsorship process, both legal fees and other fees, anything paid for the advertisements, things like that, all of that has to be paid by the sponsoring employer. From a policy perspective, the government does not want employees going to their employers and paying the employers to sponsor them through the green card process. So it is very important, if you are considering this and your employer says, yeah, I'll sponsor you for the PERM, it's just you have to pay for everything. Unfortunately, that does not work for this process. However, once you get to the I-140 stage and the I-485 or consular processing, then it gets a little bit more flexible. Either the employer or employee can pay for those fees. All right, let's talk a little bit about dual intent. So there's many non-immigrant visas that do not allow for dual intent. And what this means is that these visas say, we will grant you this temporary visa, but only if you can prove you have a foreign residence abroad that you do not intend to abandon. So these are things like the F1 student visa, the TN work visa. These have very high standards for proving non-immigrant intent. They really want the applicant, in order to qualify for the visa, the applicant must convince the officer that they really do intend to return to their home country. They do not want to stay in the United States permanently. There are some visas that are specifically dual intent. The H-1B and the L are in the regulation, specifically says like absolutely no issue if you are applying for your green card and then you also are on this temporary work visa, that's fine. They even have special permissions that allow them to travel during the green card process, but that's only for the H-1B and the L. The O is listed here. It's what we kind of call a quasi dual intent visa. There is kind of it's not quite as favorable as the H-1B or the L. You don't get the benefit of being able to travel with the green card application pending. However, the language is very, very permissive in terms of proving the non-immigrant intent. It, kind of says even if you have an immigrant petition filed, you still can potentially qualify to extend your visa. The E2 is another visa like this, the E1 and E2, where the language is more permissive. You are permitted to kind of move your residence to the United States, but they still do technically, want you to explain that you don't intend to live there permanently. So if you are on a visa like a TN and you are going through the green card process and you do want to, switch to an H-1B, there can be benefits to that. Hypothetically, like it is possible to go directly from the TN to the green card. It's just requires a bit more strategy and can be a bit riskier. All right, let's talk a little bit about this. So considerations from moving from that temporary visa to a permanent green card. So timing and your underlying status, you always want to be keeping in mind how much time is left on your underlying visa. As I was just mentioning with these different visa types, some visas are harder to extend. And are subject to more scrutiny once you have filed an I-140. Some, are going to be impossible to extend, once the green card petition is filed. So you do want to keep that in mind. In particular, if your goal is to stay in the United States the whole time, to have unbroken work authorization the whole time, you do need to be looking at your visa and looking at your green card process and making sure you've aligned for that. Because Again, like if you have, if you've just filed an I-140 and now you need to go a week later and renew your TN visa, the consular, the Customs and Border Officer or the consular officer might look at that application, see that an immigrant petition has recently been filed, and feel that, the TN standard for non-immigrant intent is not met. So you do want to keep that in mind in terms of timing. Perhaps if you're on the TN and the renewal is coming up, perhaps you renew it before you file your I-140. Also, just be thinking about, do you want to adjust status in the US? Do you want to get the green card through consular processing? What are your travel needs? Are you on an H-1B or an L that would allow you to travel, or are you going to be, in the US once the I-485 is filed for several months? Is that going to be okay with you? You always want to be thinking about those things. Also family, do you have children that also need the green card? If you have children, you may want to, file early to avoid any issues with children aging out, because at a certain point, they won't be able to join the application anymore. If they get married, turn 21. So always good to plan ahead. All right, let's talk a little bit about the green card interview. As I mentioned, everyone who goes through consular processing will attend a green card interview. People who apply through USCIS, sometimes they will, sometimes they won't. It does depend. What you want to do ahead of time is you do want to review the immigrant visa petition. And the green card petition. So the immigrant visa petition, generally that's going to contain more details about the company, about your job. The green card petition is going to have a lot of your biographical information, your employment information, address history, immigration, criminal, history, if any, family relationships. So you want to make sure that all the information you have there is accurate. You want to organize and print documents to bring to the interview. So good idea to bring perhaps a binder with you, something where you'll have the documents in a way that you can easily grab, a document and provide it to the officer if they ask. You also want to bring the original documents that you submitted copies of. So if you've submitted, copies of your birth certificates, your marriage certificates, divorce decrees, you want to bring the originals with you and then also bring a copy. The officer should have a copy, but if they want to look, they may want to look at the original, they may want an extra copy. Always better to have it with you. You want to ensure your medical exam has not, expired. They've changed this and made it more permissive, but you do have to have a medical exam, and especially if you're doing consular processing, there's very specific panel physicians you have to go through, and each consulate and country will have their own procedure for that and their timeline for that. So you do want to make sure that you're doing that properly. And then if you're filing with USCIS, making sure that you've done your medical exam within a recent enough time frame that they'll accept it. You want to get updated proof of employment from your sponsoring employers. So if you're currently working for them, you might get just an updated letter. If you are going to work for them once you get the green card, you would also just get that confirmation from them that they, still intend to employ you in the job that was outlined in the PERM application. Also a good idea to bring proof of your maintenance of status if you're doing an I-485 adjustment. So one of the requirements to adjust status is that you have to have always maintained your status. There is an exception for employment-based applicants where maybe like if you had some minor violations in the past, maybe you had an H-1B back when there was no grace period and you overstayed by a few days, what is permitted for employment-based applicants is this exception under something called INA 245K. This is where they'll only look back as far as your most recent entry and see if you've had, more than 180 days of kind of status violations or working unauthorized. And if you haven't, you can still adjust. So even if you've had some really minor violations, it's always important you have to tell your attorney so that they can build in that strategy. And that if it comes up during the interview, you can explain that you're still eligible to adjust under this exception. Also a good idea to meet with your attorney and do a practice interview. Even if you think you feel comfortable or you know the information or it's about you, it's still a good idea to just do some practice questions, even if it's not with your attorney, with your spouse or with a friend. These can be nerve-wracking situations and you just do, you may be more nervous than you anticipate. And even just running through some practice questions a couple times may give you more ease in the interview. And then particularly if you have, a more aggressive or unfriendly officer, it's just always going to be better to have practiced a bit. All right, so what is porting? So because this PERM process, as we've discussed, is a very long process, it's very common that during this process, people will want to change their job, or ask, what are my options? If this company's gone through a certain part of the perm for me, will that help me? Can I go to another employer? So the porting does allow somebody to change to a different employer, but it only becomes available at the very, very end of this whole long perm process. So porting allows employees to change employers after there's an I-485 application filed that's been pending for at least 180 days. Um, the I-140 connected to the I-485 also has to be approved before the porting request can be approved. So maybe you had one employer who filed for you, the I-140 is approved, I-485 is pending. Now, after 180 days, a new employer wants you. At that point, you can port to the new employer. As long as you can show that the new job is in the same or a similar occupational classification as the job offered to you, that is the basis of your green card petition. So for example, if you got a perm approved as an accounting manager and now another accounting firm wants to hire you as an accounting director, that's likely going to be fine. If you want to completely switch your job, your perm was approved as an accounting director, and now you want to become, a wedding photographer, that's not going to be possible under this scenario, this porting scenario. So it can be a very, favorable option, but again, only becomes available at the very end of the process. Can I change employers after I get my green card? I think again, because it's a very long process, very long, runway where you're working with one employer. Many people want to know, if I get a better job offer after I get my green card, can I leave? So when you obtain this employment-based green card, you're signing documentation, the employer is signing documentation, and what those forms that you're signing are saying is that you attest that you intend to accept this job offer, this full-time permanent job offer under the parameters that are outlined in the paperwork. There's no willing, qualified, and available U.S. workers for this job. So that's all to say that if you get your green card and you quit the next day, that can look suspicious, right? If you get your green card and something reasonable happens, maybe your spouse gets transferred, you get a new job offer that's just too lucrative to pass up. Once you have that green card, nothing stops you from taking that new offer. You can quit. Usually we recommend that you want to work for that perm employer for at least a few months. The place this would most often come up is during the naturalization process. This is where the officer, would look at maybe the employment history, the basis for getting the initial green card. And if there was anything that looked suspicious and, getting the green card and then quitting the next day could look suspicious, that's something they could definitely look into. So again, once you have your green card in hand, you are, a permanent resident of the United States. This means you can work anywhere. So technically, you do not have to stay with that employer. But again, you want to be careful because you got the green card only on the basis of saying you did plan to work for this employer. So if your mind changes immediately, the government could fairly ask, what happened, just to make sure there was no misrepresentation. All right, so we've reached the end of the presentation. I see there's a couple questions here. Somebody said, my attorney submitted the I-140 and the I-485 concurrently. It's been more than 21 business days, but I haven't received a receipt notice. It doesn't seem to be filed. Are there backlogs for accepting documents? So yes, unfortunately, it is a known issue right now that they are taking a long time to issue receipt notices. I would ask, have the checks been cashed? Again, we're seeing issues with that as well. If something was filed, at a lockbox, then usually after 30 days, there's an ability to follow up. So yes, there are backlogs. I would say keep checking to see when the checks were cashed, if you used a check, or if the, payment has gone through, that can sometimes be a sign that the case has been accepted, but it is a known issue, that they're taking a long time. Someone's asking, is it possible to switch from adjustment of status to consular process? So when you filed the form I-140, there's an option you select that says either I plan to consular process, I plan to adjust status. So based on that answer, once the petition's approved, USCIS, if it's consular processing, they'll send the I-140 approval to the National Visa Center. Or if it is approved and you're going to adjust status, they'll wait to receive the I-485. It is possible to switch, like if you've checked adjustment of status, it is possible to switch to consular processing, but it can take some time because you may need to file an additional form to basically get USCIS to actually send the approval notice and the approved petition to the National Visa Center. So it's actually much easier to switch the opposite way. If you have checked consular processing and then you decide that you want to do adjustment of status and you're in the United States, you just file Form I-485 and you notify the National Visa Center. But switching from adjustment of status to consular processing can be, more of a headache with a form that has to be filed, with a fee that has to be paid, and kind of several months of kind of tracking it. Perfect. So those were all the questions we had. So I will close here. Thank you, everyone, for your great questions, and I hope everyone has a wonderful day.